Can child support, whether prospectively or retrospectively, be waived by the child support payee? The easiest of these two questions to answer is the second one, i.e., can child support be waived retrospectively by the child support payee? The answer in Utah is yes, if the parties comply with the provisions of Utah Code Section 78B-12-109. Here is that code section in pertinent part. Number 1, waiver and estoppel shall apply only to the custodial parent when there is no order already established by a tribunal if the custodial parent freely and voluntarily waives support specifically and in writing. Waiver and estoppel may not be applied against any third party or public entity that may provide support for the child. A non-custodial parent or alleged biological father in any paternity action may not rely on statements made by the custodial parent of the child concerning support unless the statements are reduced to writing and signed by both parties. Utah Code Section 78B-12-109 thus expressly limits application of waiver and estoppel to those situations where there is no prior child support order. Now, the next question is whether parents can agree prospectively to waiver of payment of child support to the would-be child support recipient, the payee in other words. Some will tell you no, and others will tell you yes. I believe the answer is yes under certain circumstances, and I'll show you why. Utah Code Section 78B-12-210, entitled Application of Guidelines, meaning child support guidelines, and Use of Child Support, provides in pertinent part at subsection 2a, quote, the guidelines shall be applied as a rebuttable presumption in establishing or modifying the amount of temporary or permanent child support. B, the rebuttable presumption means the provisions and considerations required by the guidelines, the award amounts resulting from the application of the guidelines, and the use of worksheets consistent with these guidelines are presumed to be correct unless rebutted under the provisions of this section. And subsection 3, and pay close attention to this part, a written finding or specific finding on the record supporting the conclusion that complying with a provision of the guidelines or ordering an award amount resulting from use of the guidelines would be unjust, inappropriate, or not in the best interest of a child in a particular case is sufficient to rebut that presumption in that case. If an order rebuts the presumption through findings, it is considered a deviated order. Subsection 4, the following shall be considered deviations from the guidelines if A, the order includes a written finding that it is a deviation from the guidelines, B, the guidelines worksheet has 1, the box checked for a deviation, and 2, an explanation as to the reason, or C, the deviation is made because there were more children than provided for in the guidelines table. So while parents cannot simply dictate to the court that no child support will be paid due to the agreement of the parties alone, if the parents can persuade the court that requiring one parent to pay child support to the other would be, as I just quoted, unjust, inappropriate, or not in the best interest of a child in that particular case, and if the court makes findings of the same, then it is possible for such a waiver of payment of child support by the payee, or the would-be payee. As you can imagine, such situations are rare. The only times I have succeeded in getting payment of child support waived, going prospectively, is when the child support would-be recipient convinces the court that he or she does not need the money and can adequately provide independently for the child or children financially without contribution from the other parent. Rarely does a parent fall into this category. Or the would-be child support obligor, the payor, the one who would be paying the child support itself, proves that he or she cannot obtain enough money to support both himself or herself and the children. Thankfully, most parents do not fall into this category either. Most people who don't want to pay child support or pay the amount of child support required by the child support guidelines aren't against supporting their children financially, but they object to paying the other parent money that he or she would receive. If that is your concern, and it's a valid concern for many, the solution does not lie in paying no child support, but in ensuring that the child support payee spends the child support funds for the needs of the children. The Utah Code provides that the court can order that the child support obligee, meaning the payee, the one receiving the money, account for how he or she spends child support funds. Utah Code Section 78B-12-218, entitled Accountability of Support Provided to Benefit Child, Accounting, provides, quote, 1. The court or administrative agency which issues the initial or modified order for child support may, upon the petition of the obligor, order prospectively the obligee to furnish an accounting of amounts provided for the child's benefit to the obligor, including an accounting or receipts. Subsection 2. The court or administrative agency may prescribe the frequency and the form of the accounting, which shall include receipts and an accounting. And subsection 3. The obligor may petition for the accounting only if current on all child support that has been ordered. Truth be told, it is very hard to get a court to order the obligee to provide an accounting. So if you are seeking such an order, make sure you have good arguments for it. What constitutes good arguments, you may ask? Well, a couple of good examples would be showing that the obligee is a spendthrift, or cannot manage money, or has addictive, expensive habits like gambling, substance abuse, excessive credit card debt, etc. Another one would be that the obligee does not provide adequate housing, food, and clothing and other necessaries for the children, even though there is enough money to do so.